Quintessa, Ms. Hall, and Mr. Randolph Hall. Is that correct?
Yes.
All right. And there's another young lady with you all. Can I get you all? Can you just state your name now?
Yes, my name is Javette Hall.
I'm the attorney for both SZ Waco Apartments LLC and the Sion Group, both defendants and counter plaintiffs.
Okay. And I have a Michaela Jones. Ms. Jones, how are you affiliated with this case?
I'm the regional manager of the Grove at Waco.
We are here for a small claim suit. Cause number is J2V25-0276. As plaintiff, I have Ms. Quintessa Hall and Randall Hall, and also assisting them would be Ms. Javette Hall against defendants in today's case, SCSZ Waco Apartments LLC, Sion Group LLC, uh, represented by attorney of record, Ms. Jenna Bedingfield, and the witness I assume would be Ms. Michaela Jones. And so what's going to happen next is I'm going to have all those sworn in with the exception of Ms. Bedingfield. She's a licensed attorney in the state of Texas. Therefore, she's considered a member of the court and does not have to be sworn in. And with that being said, all parties other than the attorney, please raise your right hands. Do you solemnly swear in or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I
I
do.
do.
All right, now that we've got that part out of the way, what I want to do next is explain how the case is going to go. Ms. Hall and Mrs. Hall and Mr. Hall, you all assume are not licensed attorneys. So I don't know if you've been through this before in regards to filing a case and knowing the process and so forth. Are you?
No.
No.
And so here's what happens. You're going to get the opportunity to speak first. All right. It's going to be up to you to provide proof to me by preponderance of evidence that the defendants that you named in this suit owe you money, and that's what you filed. Now, whomever speaks in the presentation may get asked questions, which is considered a cross-examination by Ms. Bedingfield. That's kind of how the process goes. You're going to speak first, present your case. Ms. Bedingfield may get the opportunity to cross-examine you, and then afterwards, you'll get the opportunity to clarify anything that you may have said in your presentation, which is what I consider a redirect. Okay. Now, whomever it is, again, want to make sure you're clear. Whomever it is that speaks may get cross-examined. She doesn't have to make it cross-examined. I'm gonna make sure that's clear. Now, one thing I did skip, which is opening statements. We're not gonna go there. I don't think there's a need to go there for as opening statements. I have your documents that you've already filed, and I'm gonna go over those as to what I've received so far. But opening statements, we're not gonna do that. And I'm trying to avoid closing remarks as well, because we would try to keep this simple as possible in people's court. Now, with that being said, once you're through the halls, I will give the defendant the opportunity to defend themselves. They may call their witness, Ms. Jones, to testify. And you, the plaintiff, Ms. Hall, may get the opportunity to ask Ms. Jones questions about this particular case. That's considered your cross-examination. Again, you want to ask questions. That's going to be the key. And in our realities, what you're trying to do is build your case. That's just plain and simple. So she may get cross-examined if she testifies by you, and then afterwards, the attorney will get the opportunity to ask her some questions, and that's kind of clarification, redirection, in regards to that right there. So hopefully we could get this done within an expedited time frame, but also I want to make sure that you get the opportunity to prove your case. Now, I may ask questions throughout the hearing just to develop the facts of the case. With that being said, I received several documents from you, the plaintiff, Ms. Hall, along with your petition, everything that you filed and that was served upon the defendant. I received another email document, set of documents that I believe you emailed to the court. And I'm just going to briefly go over those. And before I do that, I need to know if you sent everything that you sent me to the defendant.
I did.
Okay, good deal. And so the court clerk went through and they tried to organize everything the best way possible and make them somewhat exhibits, okay? And so the first thing that I have, and I'm going to consider this plaintiff's exhibit 1, is a lease agreement. It's a housing lease, all right? That's going to be what I'm going to consider plaintiff's exhibit 1. It goes all the way to the leasing addendum. The next document I have is, it goes along with the plaintiff's exhibit 1, which is the room assignments. And I'll just say that's plaintiff's exhibit 2. The next set of documents I have, it's email correspondence between you and I believe the apartment complex. And this is the payments that were received. This is starting August 1st of 2024. And this goes all the way through, looks like March of 2025. I'm going to consider this plaintiff's exhibit 3. When I said exhibit, means that, documentation, proof, whatever you want, plaintiff using the court. All right. The next document I have is an email. It's dated March 10th, 2025. It's a move out statement from the Grove at Waco. And then the next page, it talks about the current and future scheduled charges. And it's a 3-page is what document or correspondence I have. I'm going to consider that plaintiff's exhibit 4.
Judge, may I interrupt you just for a second? I want to
Sure.
make sure I'm trying to shuffle these and
Sure.
keep up with you.
Sure.
Can you tell me what's on the top of the page for plaintiff's exhibit 3?
Sure. Plaintiff's exhibit 3, at the top of it on the left-hand corner, it's a Gmail icon, and
Okay.
then above that it says payment received. One message, it has the no reply, and then along with it, it has, and I can just show you what. I don't know if you're able to see that.
Oh, let me see. I don't. Okay, I thought that says you're almost home room assignment.
No. That is going to be exhibit 2.
Okay, I got that one.
Okay,
And
and
so
then,
the next one says payment received.
yes,
Okay, I had
yes,
those put together.
yes.
That was my confusion. Hang
Yeah,
on. So that's
I put all of those together, all of those email correspondence as far as payments received. I put all of those together,
okay.
and I'm just considering that plaintiff's exhibit 3.
That's perfect. Thank you.
Okay. And again, they weren't together. She's not an attorney, so I just
No,
try my best.
I'm fine with that. I just want to make sure we're all on the same page.
Gotcha. So the next document I have, it's another email correspondence between the tenant and the apartment complex, and it looks like they sent her an email, and it's at the top of it. It reads move out statement from the Grove at Waco. That right there, and then afterwards, looks like it went into far as the installed current and future scheduled charges. And so those 3 pages, I'm just considering plaintiff's exhibit 4. All right. The next, again, it may be somewhat out of order based on what I received, but I try my best. The next document is a mutual termination process email that was sent to the plaintiff. There's an email. Do you have that dated November 13th, 2024?
Yes, sir, I do.
I'm consider that one plaintiff's exhibit 5. The next one, it's an email from the plaintiff. Now, if this is, I don't know if this is an email, looks like it's an email, maybe a letter, dated April 4th, 2025, to the Grove at Waco. Looks like it may be mailed, I don't know. But it just reads to whom may concern. I am including this letter in a money order. I'm including with this letter a money order in the amount of $5.99 to pay my April rent for the Grove at Waco. And so this right here, I'm just going to consider this plaintiff's exhibit 6. You still following me?
Yes, sir.
Okay. The next one I have, it looks like it's correspondence from the Grove at Waco to the defendant. The date on this letter is May 13th, 2025. At the top, right in bold print, it says the balance due today, $2,309. Then it's addressed to the tenant, which is the defendant in this case. It has a unit to be determined, and then it's a start date, 8/16/2024. Original end date, 7/21/2025, and just says a statement reflects current balances as of today. And then there's another page after that talking about the balances. And then afterwards, look like there's some email correspondence between the parties. Then it talks about future and current schedule changes, repayments. And it looks like it's just some different correspondence going back between the plaintiff and the defendant. And I'm just going to consider this plaintiff's exhibit number 7.
Okay, so I want to make sure, so on plaintiff 6,
Mhm.
do you have, are there numerous letters with the check copies behind them? Or so
I might have
there's,
separated. I might have separated those. You said numerous letters with.
yes, sir, because it's essentially a similar letter that she sent April 4th, May 2nd, June 9th, and July 1. Are those all behind P6 or did those get separated out?
I see what you're referencing, and it may have gotten separated. So,
It doesn't matter to me, Judge. It's whatever easiest for you. And I just want to make sure that we're talking about the same thing.
what we can do, I see what you're referencing. So are you referencing the Chase payments?
Yes, sir.
Okay, and the first one has a date 4/4/2025, a
Yes,
509.
sir.
Okay, we can make all of that plans exhibit 6.
Okay, I'll clip those back together.
Yeah. Are you following, Ms. Hall?
Yes.
Okay, all right. Okay,
And then, Judge, so I want to make sure then that I know what is behind plaintiff 7 because I had that simply as a 3-page document with nothing behind it. So,
okay. So we can make that as it is. Keep that plaintiff's exhibit 7, the 3-page document.
okay. Oops.
And the 3-page document we're referencing, that's the one that's dated May 13th, 2025.
Yes, sir.
And it has the transactions or the scheduled installments. And the second page has the scheduled installments and payments as
Yes,
well
sir.
as payments. Okay, so that's going to be our plaintiff's exhibit 7. Saul, you still there? You follow me as well? Good. Okay, all right. So after that, that's where it looks like it's some email correspondence between the plaintiff and the defendant to Baller in a Dream 85 at yahoo.com. Is that
Ballerina. Oh, yes. Ballerina
Okay.
Dream 85.
Ballerina? Lord have mercy. You did say ballerina.
Judge, I read it the same way as you did. So,
I would have got it. All right, Lord have mercy.
I was assuming she was a basketball player, Contessa,
Yeah,
because
I
I read
was.
it as Baller in a Dream 85. So,
Yeah, okay. I see. Look, okay, kids. So, ballerina,
okay.
ballerina dream 85. So you got that email correspondence. It looks like afterwards, after that right there, you had current and future scheduled charges. So I assume all of that was together.
3-page document, Judge.
Yeah, look, that's a 3-page document.
Okay.
And that one, we are going to make plaintiff's exhibit number 8. And then afterwards, looks like it's some correspondence between the Grove and Waco dated August 22nd, 2025. And it has just statements, has some scheduled installments. Then the third page has housing and housing agreement in future scheduled charges. And the fourth page just continues on with that. So we can make that plaintiff's exhibit number 9.
And which document is this? I'm sorry, I didn't catch that.
Sure. It's it's some correspondence sent to you from the Grove at Waco. At the top left, it has their icon, the Grove at Waco, the statement date, August 22nd, 2025. Underneath that, it says balance due today, $0. And it's addressed to you. And then it has unit to be determined, your start date and your original end date. And then it just goes on further to say that this statement reflects your current balance as of today. Please be aware that you're at that as applicable, additional installments will continue and so forth. Do you see that?
Yes, thank you.
All right, and then it said the second page has account credit balance. And then the third page has housing agreement and future scheduled charges. And the fourth page continues on. Right, okay, all right, so that's gonna be Plaintiff's Exhibit 9. Okay, so I don't know what happened next. I don't know what came next. Honestly, there was, I have some UPS tracking. As well as, some proof that items were sent certified mail. And I also have, looks like a remittance advice showing the $5,165. And then looks like it has a date that it was scheduled to arrive September 19th, 2025 from Credit One Bank. And it's addressed to the plaintiff. So I have that as well. So which one would you all like to consider plaintiff's number 10 or 11? So let's do this. Let's just go ahead and let's make the refund and proof that it was mailed, make that plaintiff's number 10, exhibit number 10. And this is dated 9/11/2025, check number 2421, and amount of $5,165. And then the UPS tracking, we're gonna make that plaintiff's number 11.
UPS or USPS? It's the postal service.
USPS, this
Yes.
right here, bunch that was submitted,
Okay.
and just showing that they were mailed out and delivered and so forth.
All right.
No, just
So
showing
that's
it.
gonna be P11.
Yes. Yes. And that this right here, I believe, was included somewhere in the middle, but I had
Yeah.
separate. I didn't know exactly where and how I went. So I'm just trying to make sure I keep a good flow. Everything. And the reason why I did that is to assist both parties. So whenever you are referencing something, either party, you would reference plaintiff's exhibit, 1, 2, whatever. And therefore we all can be on the same page as to what you're referencing whenever you're making your statements. Okay? All right. Now I have all of the plaintiffs' documentation that they've submitted here. And the defendant, I don't have anything other than your answer and counterclaim. Is there anything else that you plan on some presenting to the court that I don't have in these files?
No, Judge, I did submit them, but it was, when I originally sent them, it bounced back to me. But everything, and I've tried submitting them again, but everything that I was gonna use is in Ms. Hall's documents. It was a housing agreement and a ledger. And I think there's a document that she has in the exhibit that shows what our current, her plaintiff's 8 shows what the current balance is. So I think I'm happy just utilizing her documents. Her copy of the housing agreement was a little bit, I couldn't see everything on it, but I think it contained everything my copy did. So if we get into it and I'm missing some pages, we'll deal with that at that time.
Okay. And the way it was scanned in, it is rather small. So if you see me take my glasses off because I'm nearsighted, to be honest with you, and I won't be able to read it unless I'm taking my glasses off and actually looking at it without my glasses being on. So with that being said, any questions before we proceed on with this case? All right, okay, let's dive right on in. Ms. Hall, Ms. Quintessa Hall, you're the one who filed this case as well as your father, Mr. Randolph Hall. Here's your opportunity to prove your case. Go ahead.
Alrighty. Back last year, probably about June, I went in and put in I applied for a lease at the Grove at Waco. When it reached August, I realized I was no longer needing that apartment. And so I had called to ask about how to go about canceling that. It took several weeks for me to get a response. And when I finally did, they said, you can just pay the full lease up front. You can, they didn't even, or continue paying. And so I continued paying because I wasn't able to pay that full fee up front. We get to March, I pay that March's rent, and then I get the letter saying that my lease basically they've canceled my lease. And so now they're asking me to pay what's left of the lease plus what the concession that I had on that lease all the way back to August. At this point, I'd been paying on time. I had done what was within my ability to delegate that lease. And that did not work. And so come April, I called in March to figure out why that was sent. Maybe it was April. And I was told that if I kept paying if I was able to keep making payments, it would keep it from going to collections. I go into my account, it only allows me to pay the full balance. So in order to keep that amount from going to collections, I continue to send the checks in the mail, which is why there's the April, the May, the June, and the July checks that you have as exhibits. That should be exhibit 6. All of those, because I was not able to pay it online. When I tried to contact them again to figure out how to make those payments, I got no response. I was not able to get through to talk to anybody. And then I got a check in the mail in September, and it was basically the amount that I had paid thus far. And then it turns out that 2 of the checks that I had sent in the mail were also only 2 of the 4 checks that I sent were deposited. So the amount for that check was what I had paid minus those 2, in essence.
You're referencing Exhibit 10, the $5,165 check that you received from the defendant. And
That
that
is
was for the payments that you made from the time that you moved in. Well, the could move in from the time that you started making payments up until the time that you could not make payments to the time that they terminated and completely said you had to pay the full balance.
When you say, you said up until the time you couldn't make payments, you just couldn't make them online.
right up until the time
Continuing.
I couldn't make the payments online.
Right, so you were making the payments online, and then they stopped allowing you to make payments online, so you started mailing in your payments. And with cashier's check. Then a couple of months later, that's when you received your money that you had paid, with the exception of 2 payments.
That is correct.
And which 2 payments? Well, you don't know which 2, is that right? Or
I called the bank. It was the April and the July checks, because the April one got lost in the mail. So they went ahead and cashed May's. So the tracking to show that April's got lost in the mail would be in Exhibit 11.
But it did eventually get to them.
Right, but it just got to them in May, the April check.
okay, so so they did receive April and May's checks.
That is correct.
So received
Did they cash them?
They did not cash April and July.
So it's still showing pending.
Yes.
So
Okay.
if I-
Well-
But
if I received all 4, right?
Yes, all 4 were received and signed for. I sent them as I sent it as certified mail, requiring signature upon it being received by the office.
so they got May's and cashed it.
Yes,
But April and July is still showing as pending on your end. Was it cashier's checks?
yes.
Mhm.
Money orders, my apologies.
So you moved in, you initially you had plans on going to Baylor, signed a lease, realized in August you wasn't gonna be able to go to Baylor. That's when you contacted the office. You attempted to contact the office and you couldn't get a hold of anyone. Finally got a hold of someone and they told you, well, you can't, it is what it is. You have to either pay it out or make monthly payments.
Correct.
Okay. Did they tell you at any time that you had to move into the unit?
No,
And do you remember the manager at that time?
I do not. I got bounced around to different leasing agents and I did not take down their names.
So the only thing that you were told is that either you pay it out the way it is, or you move in and continue making payments.
They never said I had to move in.
Okay, they never said just move in. Okay, never said just move in. It's just the main thing is they wanted the money. Now, you mentioned, let's talk about the concessions. Tell me, how did that go about? What was your understanding of the concessions?
The deal I signed on was $180 off of the full price of the unit. So in signing that, then I waived the application fee. It waived maybe, I think, 2 other fees. So all I had to do was pay when it came to August 1st, I just paid the $509, which is for the room and the valet trash.
Okay.
And I made that payment throughout. I just wasn't charged for utilities, but I paid for the room and the valet trash every month.
And the way these units are set up, it's not an actual apartment. You're paying for a room, right?
Correct. There's a room in a 3-bedroom apartment.
Okay. Just wanted to make sure I got this little information about what's going on. Anything else that you want to like to tell me? You provided me with lots of things. I just want to make sure that, and then you may remember something afterwards, okay? But as of right now, anything else you want to tell me before the defense attorney gets the opportunity to cross-examine you?
Let's see, which one is this? I believe it's Exhibit 9. It shows that the top is the logo for the Grove. It says as of August 22nd of 2025, the balance that was due is $0. All the other ones showed a balance of at least 2,000. And this one shows that as of that day, I owed nothing.
And what are you trying to tell me? Is this what are you taking out of this right here?
Judge, I'm gonna object that it's her sister or somebody is essentially telling her what to say. I need to know who's testifying.
Okay,
And I
so,
don't think the sister's an attorney.
well, I think it's the mother.
Is it a mother? Okay.
That's my mother.
This is the mother. So, so here's the thing. So you're objecting to the mother reminding her of what to say.
Yeah, I mean, she's the mother's essentially testifying through the daughter, and I get, I mean,
So here's what we'll do. I can understand where you're coming from, Bedingfield. So Mrs. Hall, the mom, Mrs. Hall, what I'm gonna ask that you do, you're gonna get the opportunity. So here's how we're gonna do it. Whatever your daughter hadn't said as of right now, she will get the opportunity to clarify anything else afterwards. And then also you're going to get the opportunity to speak as well. So if it's something that your daughter didn't say, you will get the opportunity to state it as well.
Okay, that's
Right.
fair.
Yeah. So if you could just take some notes, which you're being mom, your mother hen, I get it. Okay. I get it. And you want to make sure that she's doing everything she needs to do. I get that. And no one knew what to expect out of today, right? All right, so we're clear this. So I'm going to sustain her objection, meaning that I agree with her objection, meaning that you really just can't be talking to her while she's giving testimony. All right. All right. Okay. Anything else, Miss Quintessa Hall?
So at this point, back to what I was saying with this statement, I'm
Okay.
just looking for clarity as to what all of this means and how to proceed, because it seems like the check was to say the case is like it's over, it's done. There was no letter attached, but with what it came to total.
So
And
so we're looking at Plaintiffs Exhibit number 9, right?
yes.
Okay, so when I'm reading this, and let me try to figure out exactly, it says this statement reflects your current balance as of today, and it is dated August 22nd, 2025. Please be aware that as applicable, additional installments will continue to come due as scheduled under your housing agreement and will be reflected on future statements, except to the extent that we're able to mitigate our loss from your early move out. This statement reflects your account reconciliation, including previous and remaining scheduled charges without prepayments and deposits applied. A refund check for any net credit balance will be mailed to the forwarding address you have provided. If you have moved out early and we are able to mitigate our loss from your early move out, we will provide an updated statement and a further refund as applicable. You can also find a copy of the inspection report and so forth. So it does say balance zero. It's dated August 22nd, 2025, but it's also referencing um, your early move out. And your statement is you needed to get some type of clarity as to why they submitted this to you.
Not so much as, well. Sorry, give me a moment.
That's okay.
And Judge, I'm happy to address that. I mean, if you want to pivot a little bit, I'm making, just so Miss Quintessa isn't struggling to understand this, I can answer that, or Miss Jones can address that.
And so what I was leading to, this right here, if you're needing clarification as to about this right here, you can ask Miss Jones whenever she testifies. Yeah, hey, Miss Jones, could you tell me exactly what you meant out of this whenever she testifies under oath? Then you can get your clarity out as to why they submitted it to you and have a good understanding. That's why, okay, so are we on the same page now?
Yes, sir.
Okay, all
you.
right, okay. And I'm going to give the defense attorney the opportunity to ask you some questions, and then afterwards, I'm going to ask you some additional questions that she might not have brought out, okay?
All right.
All right. Ms. Bedingfield?
You ready for me? Let me get this, Judge. Want to make sure I've got this. And Miss Hall, I want to say hello. And again, I apologize for misreading your email address. Now that I see you, you do have a very ballerina-esque quality against you, and I envy you. I was way too short to be a ballerina. I had to quit that part of my career at the age of 8. Judge, do you mind if, at least on the housing agreement, if I pull it up on a shared screen so that we're all looking at the same thing?
Come on at all. Please do
I
so.
think I can. Let me get that back up. Let's see. Try one more time, make sure I got this right. Okay. There we go. Can anybody see that, the housing agreement that I just pulled up?
Yes.
You can, okay. This is a clearer version. I believe it's the same document. But Ms. Hall, is this appear to be a copy of the housing agreement that you entered into with SC Waco Apartments?
It appears to be, yes.
Yeah, and I'll show you at the bottom. You can see where your signature's down there. And this would be what we marked as Plaintiff's Exhibit 1. I'm going to have you just look at a couple of things here on the first page. What does it say the amount of total rent is supposed to have been?
Sorry. $8,268,000.
Okay. And let's see, I'm going to move over here, and I'm going to try to make this easy and kind of highlight it for you so you can see. So on the second page, it explains what the total rent is. Isn't that correct?
Yes.
Okay. And it says essentially that once you sign this contract, you were responsible for the entire $8,268, whether or not you ever moved into the bedroom or not. That's what that says, correct?
Correct.
Okay. And just again to make sure, that's where you signed it there at the bottom. Is that right?
Yes.
Okay. And then on that same page, it says when the payments are due, and it had the first day of the month, you know, starting August through July, talks about some of the late fees and stuff above that. And Judge, just so we're not having to sit there and belabor points. I am, let's see, I'm gonna move over to what I've got as page 6. I keep scrolling. 5, 6. So this is the section that talks about the breach, and it goes through. This is paragraph 18. All the numerous ways of that a resident can breach, and what the owners can do once a breach occurs. Part of that says here, you know, collecting any charges under the housing agreement, terminating the housing agreement, suing to collect past due charges. You're aware of those provisions?
Yes.
Okay. And then one other, the bottom of that, it says, let me get this. Make sure I get that right. The last sentence of that paragraph says that owner's acceptance of rent or other payment following notice to vacate or during the pendency of a legal action will not waive or diminish owner's rights under this agreement or law unless separately and expressly waived. And that's language you agreed to, correct?
You're asking if I agreed to that?
Yeah, you signed your name to this contract, right?
That is correct. Sorry, I just wanted to make sure I heard you correctly.
Yeah,
So
yeah.
one deeper here.
And then lastly, let's see. Well, there'll be a couple more things. I'll go through. There's a provision here that says, this is on page 8, says that, you know, any and all claims and disputes, whether in arbitration or court, will be governed by the laws of the state of Texas, and that the prevailing party is entitled to recover attorney fees to the extent permitted under the law. And that's, again, language you agreed to when you signed this agreement, right?
Yes.
And then you mentioned earlier, you talked about this concession agreement. Now I want the, here it is, and again, signed by you and a representative of the property. But the important thing on the concession agreement, it gave you a reduction of $2,160, but it says, as consideration for this concession agreement, resident agrees if the housing agreement is terminated for any reason, or all amounts, net amounts due and owing aren't paid when due, then that agreement becomes void and must be repaid. Now, again, that's language that you agreed to, right?
That is correct.
Okay. Now I'm going to have you, I'm going to stop sharing. There we go. And I don't have all of your exhibits pulled up so easily, so I'm going to just go back and start referring to the paper. But the document that was previously marked as Plaintiffs Exhibit 3, that was the list of all the payments received. Do you have that, Ms. Hall?
Yes.
Okay.
Just a moment.
Now, turn over, and those pages aren't numbered, so it's going to be 1, 2, let's see, 3, 4, 5, 6, 7, 8, 9 pages back. It's a payment return notification. The email is dated December the 5th, 2024.
Give me one
Yes.
second.
You see that?
Let me
And-
find. Oh, give me, sir. You said December 5th?
Yes, sir.
Give me one second.
It was on Plaintiff's Exhibit 3, I think it was
Okay, I
page
see it.
9. Okay.
I see.
And Ms. Hall, you see on that document, it looks like if you go a couple pages before that, it looks like you had made a payment on December the 2nd by e-check, but that payment got returned, correct, for insufficient funds?
That is correct.
Okay. So then you turned around and repaid that with the late fees on December 7th, and that's the next page, correct?
That is correct.
Okay. Do you understand that once that payment was late, the concession agreement addendum, you said earlier, it said that when all net amounts due under the housing agreement are not paid when due, that entire concession agreement is void and must be repaid. So
Okay.
at the time of that December missed payment, your rent went from where you had been paying the $509, that was short every month because you should have been paying the full amount due under the lease. Do you understand that?
Yes.
Okay. The if you look at what you previously marked as Plaintiff's Exhibit 8, that is the October 21, 2025 email.
I'm sorry, Miss, just want to make sure that just following you correct.
Yes, sir.
So let's just go back to that situation that happened in regards to her with the insufficient funds. So she defaulted by not making a payment. She came
Yes,
back
sir.
in, made the payment. And I just want to make sure that I'm looking through everything that was submitted. The next document is dated December 1st, 2024. That was another NSF fee.
Right.
So what you're saying is that looking at this, was she being charged NSF fees throughout the
Yes.
time after that?
Yes, sir. That did get charged, and to her credit, she paid the late fee. My only point on that isn't that she didn't pay that, it's that the concession addendum went out the door at that time. And so from that point forward, she continued to not pay the full amount of rent that was due and owing.
What I'm questioning is the accounting of it. I just want to make sure that the
We're getting to the right number.
yes, that because whenever you're looking at it, or I'm looking here that it says payments and so forth. It does not show, like on the last one on March 1st, 2025. It just shows the total amount paid $499 and total amount $509.
Which document are you looking at, Judge?
I'm looking at that last page of these payments that were received. It and I'm looking, just says March 1st, 2025, and it
Are
has
you looking at Exhibit 3?
yes, I'm looking at
Okay.
it.
Yeah.
So
So
I'm
that
just
just shows what she continued making the payment of $509 and not the payment of 600 and what was it, 80 or
so
79 plus
here's my
the
question.
$10.
Here's my question. Why, if the tenant is delinquent in making payments, why didn't she receive an insufficient fee, NSF fee for that last payment that was made?
She did if you look at let me find it, and it may have been on the one, let's see.
Because this is how I'm looking at it, and this is the way most people look at it. If the amount that she's paying does not cover the amount that's due, then the payments that she was making she'll be charged a insufficient fund. She'll be charged a late fee. And so I'm wondering, not answer why wasn't she charged a late fee for those months after she was making the payments? I'm trying to figure out, because it appears to me that yes, she was charged a late fee for some of those months, but if the rent did go up, based on what you're saying, if the rent did go up, like what the contract is supposed to say, based on what you're saying, why wasn't the tenant charged a late fee for this payment that she
Well,
made on March?
And I agree with that, Judge, and I think Ms. Jones can answer some of that. And part
Well,
of it is
okay,
there was several managers that went through this property. And
I
so
got you.
some of in fact, it kind of benefits Ms. Hall because those weren't added on. I think if we look at Plaintiff's Exhibit 8, and Ms. Hall, do you have that? That's the one I was at the top. It looks like, I don't, maybe you emailed that to yourself, or the first date is October 21, 2025. And then it was forwarding a message that was, and again, from an email address. Ms. Hall, you have that document in front of you?
Yes.
And that says that the balance due today is $3,103. That's correct?
Yes.
Okay. And if you look on the second page of that, you can see where the installments that were getting charged, it was the $679, and then with the $10 for the valet trash, the amount that was agreed to in the housing agreement, correct?
That is correct.
Okay. Let me look. And I think Ms. Hall, you haven't tried to cash that check, have you?
The check I received in September.
Yes, ma'am.
I guess I did cash it.
Oh, you did?
Yes.
Are you certain about that?
Yes. We are referring to the check for the $5,165 that I received on September 19th.
Yes, ma'am.
Yes, I did.
Okay, I'll ask Ms. Jones about that, I guess. Judge, I don't have any additional questions for this witness.
Okay, so I just want to kind of clarify a couple of things with you, Ms. Hall, in regards to, what was said in the list, and we'll go back to that last exhibit that the defense attorney referenced, and that was let's see. Plaintiff's Exhibit 8. It's dated October 21st, 2025. It was from you, and you sent that to yourself. So when did you receive this?
This email came to my Gmail account on August 4th, which was a Monday. August 4th of 2025, to clarify.
Okay, so the one above that, that was just your housing agreement. Okay. Is that something you sent to yourself before that as a housing agreement where it says Quintessa Hall forwarded 24 25 housing agreement?
Yes, I forwarded
Okay.
that to myself for
Okay,
to be able to
that
add that
makes
to
sense.
the.
So you didn't receive this email until August.
That is correct.
And that's in regards to what was due.
Yes.
Okay, all right.
And Judge, may I ask her one other question on that, just so I can make sure I'm understanding?
Sure.
Ms. Hall, what, had you been communicating with somebody at the property? I mean, that it was a human that emailed you that, though. It wasn't like it was an auto-generated statement. That's correct, right?
This was just an email. Most of the emails I got were just saying that it was from the property. So this
Okay.
was one of those emails saying it was from the property.
Yeah. This was a different than some of the other statements or whatever that they gave you that just were auto. Is that right? Or do you know? And if you don't know, that's fine.
I'm not certain of the difference between them. I just know some were sent and it had a separate document, and some were sent and it just had all of the charges listed in the email itself.
Okay.
But it's all from the same email account.
Okay. Perfect. Thank you.
Okay, and the other document that was referenced in your um statements that you previously made on the cross-examination, going to your plaintiff's exhibit 3, I just want to make sure I got a good understanding. Whenever you, after you didn't make that one payment like you were supposed to, you were assessed a fee, right?
Yes.
Okay. Were you aware that the amount had changed at any time afterwards?
No, I was not. Every time I went on the portal to make the payments for the for January through March, it continued to show the $509. If it had showed more, I would have called, or I would have just continued to pay as it was. But it only showed the 509.
And so this transaction, December 7th, 2024, that's when you made the full payment. And you you continued making the payments as you were stating on the oath based on the portal for January, February, March, April, or March, right?
Yes.
All 3 months. You made them on the portal. And the
Yes.
amount that you paid was the amount that was listed on the portal, the amount due.
That is correct.
And had you any time received any notice of late fees being assessed to the portal, whereas the amount that you were submitting wasn't the right amount?
I did not.
So you were under the assumption that you were paying the full amount that was due.
That is correct.
Judge, may I ask her another question on that
Sure.
issue?
Sure.
Ms. Hall, can you look at your move out statement? Was plaintiff's exhibit 4? And you were provided this document on March the 10th of 2025. You have, just let me know when you have that in front of you.
Give me just a moment.
Okay.
All right, I have that up now.
Okay. And the second page of that document you were provided back in March shows scheduled installments from August 1 of 2024 through July 1 of 2025 in the amount of $689, correct?
That is correct.
Okay. And it showed that you had only been paying $509, correct?
That is correct.
But they provided you notice in that document that it was $689 that was owed, correct?
That is correct.
Okay. And you had agreed to that in the concession addendum and in your housing agreement, correct?
That is correct.
Okay. So even though they didn't pick up the phone and say, Miss Quintessa, hey, you were late on this, your payment's increasing, and they very nicely weren't charging you late fees, they did provide you notice that you were supposed to be paying $689, correct?
after that last payment I was able to make online. Yes.
Okay.
When did you move? When did this was she referenced move out? And that's very critical. It's a good part of what needs to be notated in this particular case. When did you notify the apartment complex that you were moving out?
Since I never moved in, there was not a move out notice. However, when I did realize that I wasn't going to even be on the property, I called them immediately. And that was the beginning of August of 2024.
Okay, well, I'm talking about in regards to this right here, because this based on, correct me if I'm wrong, Miss Bedingfield, and I just want to make sure I'm hearing it correct. They submitted this statement to the tenant based upon the fact that someone terminated the lease, or so something's going on in regards to what prompted this right here is the question. What prompted them to submit this statement to the tenant after everything was said and done? And this was well after she defaulted in not making the payment on time. I'm just trying to get some facts
Right.
as
And
to what prompted this right here to be mailed out. And I'm assuming it was based on the fact that somebody terminated the lease.
Miss Jones, if there's anybody that is able to testify to that, it's gonna be Miss Jones.
Okay, so we will
We'll
hold
be able to, I think, clean up a little bit of that, Judge.
Yeah. Because the first page is financial move out statement PDF. That's the email from her from the Grove at Waco to the defendant, to the plaintiff in this particular case, and it's final
Right.
move out. So this right here is referencing that someone actually is moving out, and it has a move out original end date 7/21, but it's a move out.
Well, I think some of that, Judge, is when residents get an entire statement, so she was already in breach, that this way these apartment systems work. I do work for this particular company, the Sion group, all throughout Texas. And their system is in place to where sometimes when they need to send certain statements or whatever, the people in the staff, it's kind of like the headaches I'm sure you deal with, where your staff, with some of the automation that the courts have today, and you need to send something and you're kind of limited on which buttons you can choose that describe whatever. I don't know if I don't see anything on this that just says, hey, we know, other than the title. I mean, this is all auto generated. I think this was just a way to give her a statement of exactly what was owed as of the March 10th, 2025 date.
And who terminated and I assume we had to wait on Miss Jones. I would need to know who terminated the lease. Was it the tenant or was it the apartment complex?
Would you like
That's
me to
something-
answer now, or do you want me to wait?
We'll find that answer a little bit. All right. So I think that's all I need right now as far as developing the facts of everything that was just stated. And do you have anything else that you'd like to ask the plaintiff, Miss Quintessa Hall, Miss Bedingfield?
Judge, I'm good. Thank you.
Okay, and so we'll move on to the mothers. I want to say Mother Hall, Miss Javette Hall. Here's your opportunity to, make any statements to support you're not listed as a plaintiff in this particular suit. It's just your husband as listed as a plaintiff and your daughter. Your husband or your daughter can authorize you to speak on their behalf, but you cannot present anything yourself unless they give you authority to do so.
Is verbal, did it have
Verbal.
to be something pre-written, or?
You want to verbally give her authorization to assist you in your case, you can. Again, this is somewhat pro se. Go ahead. If you want to give your mother authority to help assist you to make statements on your behalf, you can, or you can call your mother as a witness. And calling your mother as a witness means that you would ask your mother questions. And you might get chastised afterwards. But that's calling your mother as a witness. So one of the two, either give your mother authorization to speak on your behalf, or you call her as a witness.
I would like to give her authorization to speak on my behalf.
All right, Ms. Javette Hall, go ahead.
Thank you, Your Honor. Okay, so my initial reference is to, let's see, this is the lease. Is that exhibit? Which exhibit is the lease? I apologize.
Exhibit 1.
Exhibit 1, and page 2, which the attorney referred to, page 2 and item 2 underpayment, and referring to that payment, it does say that the total rent stated below is a fixed price for the entire term, but we do know that the rent stated below was with the addendum attached, and that even from the first day of August, she was not required to pay the $689. So from the beginning, we were working with the $509 per month. But it also says in that paragraph, resident accepts financial responsibility for the full term of the housing agreement, regardless of whether the assigned bedroom space is occupied for the full term or at all. And this,
Could you mind you said in that paragraph, would you tell me which?
yes, page 2, line, section 2 of the lease, under payment, number 2 says payment.
Okay,
And this
Okay.
is the same paragraph that the attorney referred to. And so again, it says resident accepts financial responsibility for the full term of the housing agreement, regardless of whether the assigned bedroom space is occupied for the full term or at all. And so our understanding with this being in the lease and with the person she spoke to back in August, letting them know she wouldn't be moving in, this matches with what they said. And so I think we had a realistic understanding and expectation that when she was told that she either needed to terminate it early and pay it all up front, or just pay it out month by month because she had signed the agreement, that it would be required of her to pay it in full. So when it says that the space may not be occupied at all, then I don't understand when we speak about her breaching her contract. And so then furthermore, when we look on page 6 of the lease at number 18, breach by resident, when I read this, I see it listing 3 ways the lease can be breached. Okay, so midway through line 1, 2, 3, 4, 5, 6, 7, 8. Line 8, a few words in, it says owner may terminate this agreement for non-payment of rent or other charges, or, so number 1, non-payment of rent, or upon any conduct by resident that is prohibited by or in breach of this agreement, or if in the reasonable judgment of owner, continued residency will or may be detrimental to the educational process or the health, et cetera, et cetera. So it seems to state 3 things as to why the lease might be terminated. But if the attorney or the apartment complex says that their reason for terminating was for non-payment, and they're referring to December when there was the first late charge, why didn't we terminate it in December if you were going to hold her to that, as opposed to there's a late fee, pay your late fee? She paid the late fee. She didn't argue or try to negotiate with the late fee. She paid it. She didn't realize, or for whatever reason, that check or payment didn't clear. She immediately took care of it. And if you look through her payment history, you see month after month after month, she honored what she was told by management at the beginning of this lease term back in October. She in no way tried to get out of it. She honored her commitment. And even there were a couple other times where it may have been late. She was quick to include that late payment. And as she said, online, it never showed existing or outstanding late fees from where, as it said, she canceled the concession. And so she was actually required to pay the full $689 each month. In fact, I question how the system would have let her continue to only pay a portion of what it was saying due without late fees compounding, not even just monthly, but daily. And that negligence being cause for you to cancel this. But when I look at the late fees in her payment history, where is it? I think I only see 3. And each time she paid that. So I just,
Which exhibit are you referencing?
let me find it. I apologize, sir. That final.
The room assignment.
May I ask her a question? Because she's got the copies of the statements here.
Is it for this?
No, there's one that shows. Yeah, okay, so December 1st, the late fee,
So this is-
December 2nd, I'm sorry, tell them which statement.
This is exhibit 2.
Exhibit 2.
We're talking back to the email with the payment for that was made on December 7th.
That
Okay.
was, I don't have that as exhibit 2.
I'm looking for the exhibit that shows the complete
And
history.
Judge, I mean, if they want us to charge late fees and
No,
we can do that, but it
That's-
just makes the balance that much higher, which
that's not what I'm suggesting, ma'am.
I'm sorry, then I'm misunderstanding then.
I'm
You're referencing plaintiff's exhibit 3, and it goes through the payment history.
I'm sorry, I must have misspoke about the exhibit.
As exhibit 3, starting August 1st, it shows payments 509 and moving forward. 509 for, which this is out of order, October, November.
I apologize. We had it here. and It was actually in,
I didn't receive this.
oh, you don't have exhibit B from the defendant, Judge? Because that's what I was looking at.
Exhibit from the defendant?
Yeah,
No, I don't have any of the defendant's exhibits,
okay.
but you received them. Is that what you're saying?
Yeah, they sent her, it's their full ledger.
And Judge, I can pull that up. In fact, that version is not the updated version either. I've got one that I'm happy to share that is,
What was it
It's
that
just-
you have, Ms. Hall?
So the only thing I'm looking to state is that it showed the NSF fee on December 2nd, a late fee on December 4th of $45, and then a late fee of $35 on January 4th. It
Okay.
shows no other late fees is the point I'm making. If,
and I concede to that.
okay, and so we had every reason to believe that she was in compliance with the terms of her lease. That's the point I'm making. But then in March, what exhibit is that dated March 3rd? I mean, March 10th.
That's Exhibit 4.
The last one the judge was just referring to before I was able to speak.
Mrs. Hall, it's Exhibit 4.
Thank you, Exhibit 4. And so when Quintessa received this email that says move out statement from the Grove at Waco, that's the first thing she received that gave her any indication that anything had changed. And so she inquired, she called to find out what was this about, because for the first time, she's seeing the scheduled installments at a higher rate than she had been paying all along. And so that information was not added into anything that was sent to Quintessa until this document right here. And when she called to find out what is this a move out statement, they told her they terminated the lease because they needed to get someone in the apartment. And because they had to terminate it early, that made it an early termination, which she was held liable for.
Well,
But she was no party to signing any documentation to terminate her lease early. She was paying
Judge,
it.
I'm going to object to that on a little basis of hearsay. It's what somebody told Quintessa that Quintessa then told her mom. I think that's 2 levels of hearsay.
No, actually, she had the
So-
phone on speaker
so
and it was
let-
a
Doesn't
manager.
Matter.
So let me explain. Hearsay is quoting someone that's not actually in court, or there's no statement to assist you in your in your statement. So that's pretty much hearsay. It's not, I'm not saying that what you heard is not true. What I'm saying is you can't really use it in court. So
Okay,
you can't use what you heard said unless that person is actually in court. That's how I'm looking at it.
okay.
To
So,
put so you can't really just use it what
Okay.
that statement. So I have to sustain her
Okay.
objection in
okay.
regards to, so I have to, pretty much go
But I
ahead.
will say though that this move out statement from the Grove at Waco, Exhibit 4, was the first indicator that that the concession was canceled and that she was being required to pay all the retro concessions up front. And this came 4 months before the end of the lease, okay? So she was required to then pay the retro concessions as well as the last 4 months of rent and upfront. And so on her account online, it gave one sum that she could pay. She could not make the monthly payment. She had to pay it all or none. And so because she could not do partial payments online, and so I guess I can't say what the office said to her, we looked at it as still making sure that we don't default on the lease that she signed the previous year, we put the payments in the mail for those last 4 months, each month, to make sure that the Grove at Waco still got the money that she agreed to pay them. And so with that, and not seeing clearly in the lease where she was in breach of contract, we are at the point of why is she being required to pay this when she had no previous indication that she was in default?
Gotcha. Okay. You have anything else? Miss Hall, Miss Javette Hall?
Yeah, I guess I wanna, I guess, find out about this part for understanding. But beyond that,
And
we-
you'll get the opportunity to find out more information, especially if you're needing to get some clarification. You can get that
Okay.
from Ms. Jones. Let's say when you find out there's, won't be able to find out until you ask the source. And that'll be Ms. Jones. And your daughter would have to ask, those questions to Ms. Jones. Okay. And so what you can do, whatever questions that you want your daughter to ask, write them down. Yeah, and let her do that. Okay. Now, with that being said, you did testify on the oath, Ms. Javette Jones and Ms. Betty.
that all.
Oh my God, at all. I'll make sure, please don't send your husband down here to beat me up, okay? All right, Ms. Hall. I'm going to give Ms. Bedingfield the opportunity to cross-examine you if you feel like you need to do so.
Judge, I don't have any questions for Mrs. Hall.
Okay. And lastly, is Mr. Randolph Hall, is he wanted to make any statements?
No.
Okay, he say I'm through. All right. Okay, so with that being said, I was consider the plaintiffs to be resting at this time. All right. When I said resting, go ahead.
May I
Ms.
write a question for her? to
Sure.
ask? May I do that?
Now, if you have a question, you had to ask it now. But
Okay, because you say,
so
my-
when
if you say we're done stating our
this is
side.
right now, any questions you might have, you can ask Ms. Jones, because what's going to happen next is Ms. Bedingfield is going to call her witness, Ms. Jones, to testify. And then you will get the opportunity to ask, your daughter will get the opportunity to ask Ms. Jones any questions about anything that she said under oath or anything to help develop your case. That's cross-examination. All right.
Yeah, so I guess my question was still then, though, it's not a question, but additionally about the letter Quintessa received in August, along with the check, which suggests that she doesn't owe anything else. So that adds to our not clear on why we're still going back through the lease, when it seems that Waco has settled the case financially and she doesn't owe anything else based on what exhibit? What's that, August 22nd exhibit?
Number 9.
Based on exhibit 9, it appears that she doesn't owe anything else. And so I'm not sure why we actually even need to go back to the lease, because her original request was that she not be charged the retro payment. She just did not want to have to pay money that she did not owe.
Okay. So Okay, just to clarify, what I'm hearing is that you believe that, this letter substantiates you making all payments on time and that they settled everything.
Yeah.
Is that what I'm getting?
That is correct.
Okay, all right, okay, I got you. All right, so,
Like I said, Judge, we'll address that with Ms. Jones's testimony.
right, I just want to make sure I got a good understanding of what she was wanting to relay out of that. Okay, so with that being said, Ms. Bedingfield, here's your opportunity to defend your client.
Okay, Judge, I'm gonna call Miss Michaela Jones as my witness.
All right, Ms. Jones, you've already been sworn in on the oath. Please proceed.
And Miss Jones, explain to the court and to the halls what your title is and kind of what you do for defendants.
Yeah, absolutely. I'm the regional manager over the Grove at Waco. am employed by the Sion Group, so I oversee the property that we manage and own in Waco, Texas.
How many different Sion Group and properties do you oversee?
I oversee 7 total, so 2 in Waco, the View on 10th, and then the Grove at Waco, and then 5 in College Station, Texas.
How long have you worked with Sion Group and the Grove?
Yeah, today is actually 4 years since I have worked with the Sion Group, and then with the Grove, I believe it was end of October, early November that I officially took over the Grove at Waco. They were within the larger portfolio of Texas and Louisiana, but I did not directly oversee them until I would say early November.
Okay. And the housing agreement that's at issue today is essentially the same housing agreement that the Sion Group uses at all of their properties across the state of Texas, correct?
Correct.
So you've seen this agreement probably thousands of times at this point.
Yes, that's correct.
And Ms. Quintessa testified earlier as to some of the provisions, and I don't want to belabor the point, but essentially the way the housing agreement works is there's one lump sum that's due up front, and then the property, the owner divides that up into usually 12 payments to make it easier for the residents, right?
Yes, that's correct.
And it's often the case that a concession addendum or agreement is added as an addendum to where the rent is reduced in a certain amount unless there's some type of breach. Is that correct?
Yes, that's correct.
And that's what Ms. Quintessa executed, right?
Yes.
And we went through all of that earlier. And I'm not going to belabor that point. I'm trying to clean up some of the confusion that came up. Do you know why? Well, let me ask this first. So as soon as Ms. Quintessa was late on that December payment, as far as the Grove at Waco was concerned, and defendants, I'm going to collectively refer to the defendants as the Grove at Waco. But as far as the property was concerned, under the terms of the housing agreement, was Ms. Quintessa in breach at that time?
That's correct.
Okay. Even if they didn't turn around immediately and start charging her the full amount, she was still in breach.
Correct.
Okay. And if they made a mistake by not charging her the full amount at that time, that's on y'all, right?
That is correct.
Okay, just made me in a smaller bonus for you at the end of the year. Tell the court and the halls, because I think everybody is curious about what happened in March where this move out statement was generated. Can you just explain that?
Yeah, absolutely. So anytime we have a tenant that signs a housing agreement with us, they're in an application state, and then once they sign the housing agreement, they go into lease completed, lease executed, etc. once the guarantor signs it. So when we go to move out quote unquote financial move out process, that's actually us processing it as a no-show, skip, or eviction account, which requires future installments due. So when they were closing your account in April, they processed you as a no-show or skip, with the intent that you were going to continue to receive payments throughout the rest of the housing agreement term.
Okay. So that wasn't, the phrase on there, move out, wasn't, it was just what the system generates. Is that correct?
Correct. The system automatically generates a financial move out form or document as soon as your process is a no-show, skip, or eviction account.
Okay. And could that have been done at any point with Ms. Hall?
Correct. Yes.
So y'all could have processed that back in September of 2024, right?
Yes, ma'am, that is correct.
Okay. So as soon as she didn't physically move in.
Correct.
Okay. And Judge, before I move on from that issue, I know you were a little confused. Did that clean that up for you?
I got, the defendant's understanding of it. Yes, ma'am.
Okay. Okay. And then, Miss Jones, we had talked about a statement that had been sent out to Miss Hall, and it was what was marked as Plaintiff's Exhibit 9. Now, no, you're actually out of the office on vacation this week, so you may not have that in front of you. But I'll represent to you that it's a statement. It says August 22nd, 2025 showed that the balance due today was 0. And it looks, in fact, instead of even sharing my screen, I'm going to set it up here.
Yep.
Whoa.
I
Okay,
pulled it
so-
up on her account.
Oh, so you saw
Yes.
what it is. Can you explain to me and the court and the halls what that document is?
The one that was emailed on August 22nd, just to clarify.
Yeah, it shows a
Yes.
balance due of 0.
Yes, that was sent in error. That should not have been sent. That was an error.
And so the one that was sent right before that was actually emailed to her on August the 4th, that showed a balance due of $3,103 that's been marked as Plaintiff's Exhibit 8. On that, it says, this statement reflects your current account balance as of today. Is that still her current account balance as of today, the $3,103?
Yes, ma'am, that is correct.
Okay. And then, so why Miss Hall produced a document that was an envelope, some mailing stuff, and it showed a check for $5,165. Why was that issued?
Again, that was an error. On the 22nd, we had a new general manager start at the community, and she was working on processing this current academic term, so August 2025 through July 2026, and accidentally processed the account incorrectly, and that refunded it. And since I have confirmed multiple times that that check has been voided and that check was never cashed and for that refund check.
Okay. So, and you've confirmed that as recently as, when was the last time?
The last time I confirmed was at 2:50 this afternoon.
So actually during this hearing, you confirmed again that that
Correct.
check is void and has never been cashed.
Yes. So I received confirmation. I had messaged them yesterday just to confirm, and then received another confirmation that I'm not seeing anywhere that Quintessa Hall has cashed her refund check. The bank shows the status as void.
Okay. And so it is your understanding that the 3,000, and I want to make sure I'm quoting the right number,
$3,103.
$103, yes, ma'am. that is owed is essentially the difference in what she was paying in the concession addendum.
Yes, that is correct, except for, I do not have record of a housing installment payment, and we could have not processed it on our end. Again, I'm on vacation, not directly at the property, but I don't have a payment, by looking at the ledger for April or, July. So that would be included in that 3103.
So the two that she says, have you been able to confirm whether or not that was received and processed?
I have not been able to confirm if that was received. I know for a fact that it was not processed.
Okay. So
And which, I'm sorry, just a clarification, that was the check that she mailed to you all, that you all
Sure.
received it. That's for April and July.
Correct. Yes. Quintessa mentioned that it was received to the property but not cashed, and we have not cashed those checks. In that time frame, I was going through a management switch at the property itself, so I don't know directly where those checks are.
Okay, but you can confirm that someone at your office received those checks.
I don't have the I don't have the document in
Okay.
front of me that shows that someone from my team would have signed for that document, so I don't want to agree to that because I don't have anything in front of me that shows.
she was just saying that based on what Ms. Hall had
Yes,
stated, Judge.
Okay.
Ms. Jones, do you have anything else that you would like to add for the court? I think we've covered everything with regard to the housing agreement, kind of how we've gotten to where we are. Is there anything else you would like to add for the court's benefit?
I don't believe so.
Okay. I'll pass the witness.
Okay, Ms. Quintessa Hall, here's your opportunity to cross-examine Ms. Jones.
For the breach of contract, specifically for where it says that I was in breach, would you please just review that for me again so I can better understand how I was in breach and how that led to the move out statement I received on April 10th.
So you're asking, can you clarify on your breach from the non-sufficient fund payment to the March financial move out statement?
Yes, please.
Yeah, so the second you didn't make that payment in December and the payment failed, that's when you received the NSF fee, which is a non-sufficient fund fee, and that is when you were at breach for losing the concession.
And so even having paid that fee, that still kept it in breach.
Correct.
And then would you please go back over with me, because it's just a lot of information coming, how that was not reflected then in the next set of payments, and why on my end it only showed the 509 and it didn't show anything more or to the effect of the 689.
So why did any of the documents not reflect the 689? Is that your question? Sorry, it's very quiet on my end.
And I'm having a hard time hearing you as well.
If you just speak a little louder if you don't mind, Miss. I know you're a little nervous. I can tell, but if you could, act like are you a ballerina? Okay. I don't know what a ballerina does, but I'm quite sure you get real bold and you really want to perform. Get your confidence up and make your statement very strong. All right? All right. Go ahead, restate your question.
Oh, I was just asking if you would then go back and explain how it didn't change in your system for the payments from January to March, and why it still only showed the 509 as opposed to the adjusted charge because of the non-sufficient funds fee from December.
Yeah, I mean, great question. I am not exactly sure on the exact answer to that. I believe that it was an error on our end in the system. So I don't have a set answer for you on why that happened, other than I believe that it was an error from our, system.
Um, and then you had also shared how the check that I received in September was a mistake or an error. And I was just wanting to understand how that happened. If you're saying it was an error, how is it that then the Chicago office sent it to me, and how, like, where that came from for it to not be from Texas, if it
Yeah.
was your general manager who made, or if it came from within the general manager, that error.
Yeah, so our corporate office is based out of Chicago. That's where all of our billing goes through. So any account processing wise goes directly through Chicago. We can't cut a check physically in Waco. So it looks like there was an error made in August, which triggered the refund check to be processed, and then Chicago, they directly cut out that check and sent it to you. Once we saw that and noticed it, we went ahead and voided the payment of the check until we got to court, and we could sit here and Miss Bedingfield could represent us.
Sorry, give us just a moment.
Yeah, I ask for a question.
This is, what if, I'll tell you what. Is this, so you're still wanting to ask questions, during cross-examination?
That is correct.
So this is what we can do. All right, you can continue asking the questions that you have. Then afterwards, we're gonna take a recess. And then after we come back from recess, we will give the opportunity, we will give the defendant's attorney the opportunity to redirect. And then if there's any other questions that need to be asked, we can do so then. All right?
All right.
Okay. Any other questions that you may need that you have right now?
If I could get clarity on why I wasn't notified up front or sooner as to the termination of the lease, or that breach in the lease back in December, because in the lease it says if there was a no-show or a skip.
I don't think it says it in the lease about the no-show or skip. I think that may have been an internal. That's because that wasn't mentioned previously, as far as in lease. I think that's something internally that they do, not something that was actually agreed upon. Am I correct, Miss Jones?
Yes, that's correct.
Okay, all right.
There's language, Judge, just to make sure, I want to make sure that nothing's being misrepresented. That phrase, that language, no show or skip or whatever, is not in there. There is language in the lease that talks about failing to occupy the unit.
But there's also language in the lease that says that they, according to what they've presented, saying that she has to move in. Whenever I looked at it, I just, let's be specific while we're talking about that. What are you referencing, Ms. Bedingfield, in regards to how this breach, no show, evict, or skip? Where does it explicitly say so, or how is it referenced to a portion of the lease? Because that was it. That's
And Judge, that was just on why that was processed. Once she refused, so let me make sure I've got it. And Michaela, you may know this housing agreement better than I do.
go ahead. Let me, you said it, so it's
Yeah,
is
it
is it
said,
something in
well,
the lease? I'm just trying to figure it out. I need to get facts.
the where is that? Hang on.
Tell you what, we're gonna take a
Right.
recess. We're gonna take a recess.
Okay.
I'm going to give you, Miss Bedingfield, the opportunity to contact your client and y'all figure this out about which portion of the lease where it says so or where we can link it to. And then you, Ms. Hall, and your daughter, Ms. Hall, you're gonna get the opportunity to clarify your questions, then we're gonna move forward. We're gonna take a 5-minute recess, okay? I'm gonna put everyone back in the waiting room.
Okay, thank you.
Well, we'll do, yeah, we'll resume at 3:30. All right, court's now back in session, call number J2V25-0276. We will resume the cross-examination of the defendant's witness. Ms. Hall, unmute your microphone. All right. We will go into the clarification about the lease whenever the defendant's attorney gets the examiner to redirect her after your cross-examination, okay? All right, so, go ahead, Ms. Hall.
Alrighty. Didn't the management team, the office, have the responsibility to let me know that not showing up would put me in breach of my lease?
Is that a question for me or Ms.
I'm sorry,
Bedingfield?
yes, yes.
Okay. Say your question one more time.
Didn't management, so the management office, management team, have the responsibility to let me know that not showing up would put me in breach of my lease or my contract?
I'm not fully understanding your question because there were multiple communication factors from you letting us know that you were not moving forward with the housing agreement. And so that's why we would process you as a no-show because you never actually occupied the unit or the bed space itself.
Right, but if in the lease it says that whether I occupy the space or not, I'm still have to pay, or I'm still, if I'm understanding it correctly, if it's saying that, here, I will pull it up so then I can make sure I'm reading it and following along correctly.
You're referencing your lease, correct?
That is correct. So that should be exhibit 1. And I am pulling from, let me just get to the right spot because I was in the wrong spot. It should be section 2 about payment.
Ms. Hall,
And
may I pull that up so that we're all looking at the same one?
yes, please.
Judge, are you okay if I share my screen again?
Fine, go ahead.
Okay. There we go. Everybody see it?
Not yet. There we go.
Okay. Alrighty. So correct me if I'm wrong in my understanding of this, but it says the resident accepts financial responsibility for the full term of the housing agreement, regardless of whether the assigned bedroom space is occupied for the full term or at all. So if I didn't occupy it at all, but I still remained financially responsible, can you help me understand then just maybe just break that down for me a little bit more? And that might be more so towards you, Ms. Bedingford. I'm not entirely certain as to how just the breakdown in communication took place. And if I didn't state that very clearly, please do ask further questions.
Judge, if you would like, I can try to answer that. I mean, I am their corporate rep all throughout the state of Texas. I can try just to make that easier, or Ms. Jones can try. It's whatever you prefer, Judge.
I guess
don't
the question is what I'm getting, where, how is it, and correct me if I'm wrong, because I want to make sure I have a good understanding of your question. Are you asking how could you as the plaintiff and tenant in this case be I guess in default of the lease by not moving in if it says so here that you whether or not you occupy it or not. Is that what I'm getting?
Yes.
And
Okay. No,
let me-
no, go ahead, Ms. Bedingfield.
well, so I think part of May, is addressed in the lease. So under paragraph 21, there is a provision that says that, if the assigned bedroom space or apartment is abandoned, or your right to use it has been terminated, and it kind of goes through that. So it does address that. I just want to make sure, Ms. Hall, that you understand that the breach didn't occur because you failed to move in. The breach occurred once you had that NSF payment and
Miss
Uh,
Bedingfield, no disrespect. Your client said so under oath. The reason why she received that letter was because someone internally. And
right.
this was in March, not in December, but this is
Yes,
in
sir.
March.
I agree.
So I just want to make sure we're
There's
clear.
there's two separate things here, Judge. The breach
Alright.
occurred when she failed. As a result of the breach, then you go back to paragraph 18, breach of resident, that the owner has the right to terminate the housing agreement or the resident's right to occupy the premises. That's where she lost. That's why it was terminated, was once she was in breach, and that's where she lost the right to occupy. Does that answer your?
Ms. Hall, I'm just trying to develop the facts of the case. Ms. Hall, does that answer your question? I'm just trying to develop the facts. I'm just trying to get the facts.
I'm still a little unclear. The part that you're highlighting, you're saying that's what creates that, for lack of a better word, allowance for the move out statement that I received, is because, would you highlight the part in the breach that you're referring to? Because I'm not certain if I'm seeing it in what's highlighted right now, or if you would just explain it further. Maybe
Well,
I'm
and Ms. Jones is the regional manager. I mean, she can kind of explain that, but I think I just wanted to answer the question, I think, that came from the judge about why the property had the right to terminate the housing agreement and a right to occupy. And if I understood your question correctly, Judge, that right comes from that provision that's highlighted. Ms. Jones, I'll let you address why that move out statement was generated.
Yeah, again, like I mentioned earlier, the move out statement, the second that you should have received those consistently throughout your scheduled charges each month. And that only came because we went onto your account. We were able to view that you were delinquent back in December, which breached your concession. And then we processed the move out, quote unquote, financial move out statement, which proceeds with scheduling automatic payments each month.
What about this highlighted portion? Tell me a little bit more about that, Ms. Jones.
So terminating this housing agreement and or the resident's right to occupy the premises. Is that what you're talking about?
That's what your attorney highlighted for us to
Yes,
reference.
correct. So because of the breach from the non-sufficient fund payment in December, we were able to proceed with terminating the housing agreement because of the breach in the agreement from the non-payment. And that's when the March financial move out statement was processed.
So that could have been processed in December, that could have been processed in January, that could have been processed in February.
But as
Right.
but as we see, there were lots of errors that occurred and lots of management that was transitioning in and out of the apartments, right?
Correct.
Okay, all right.
Yeah.
Okay, anything else you want to ask, Ms. Jones? You can stop sharing your screen. I think we're through with that, Lisa.
Okay.
I have no other questions.
Ms. Hall, do you have any other questions, Ms. Jones? Did I hear you correct? You have no other questions?
as of right now.
Okay, all right. Ms. Bedingfield, you have the opportunity to redirect. Go ahead.
Judge, I don't think I have any further questions for this witness.
Okay, I just want to ask a couple of questions. The one question that I'd like to get, just trying to develop some of the facts of the case. Does your lease specifically say an NSF fee is a breach of the lease? If someone is late, or not late, but if they, if there's a insufficient, if they receive an insufficient, does that is that grounds for terminating the lease or grounds for breaching the lease?
Michaela, do you have a copy of the lease in front of you, or do you need me to pull it up?
If you don't mind pulling it up, I'm on one screen, sorry.
Okay.
And then, Ms.
Uh,
Bedingfield, you're the attorney. You can help with this question. I just need a clarification because it's important.
Yes, sir. And it is on the lease on, I'll make sure I get you to everything. Paragraph 2, that's on the second page,
Mhm.
is where that is addressed. And I've got it in front of me, but I think my eyes are playing out, so I'm going to look at the one on my screen. So
Yeah, go ahead.
there,
You can pull up the
it
one on your screen.
shows,
You can show your
sir?
screen again.
Okay,
You can show your screen. Go ahead.
let me share it again. Share. Okay, so we have that. Everybody can see that?
Mm-hmm.
Okay, so right here up at the top of that, Judge, it says, resident, I'm gonna just highlight this. Here we go. Resident agrees to make full and prompt payment to owner according to the payment schedule specified below without demand of owner, together with additional charges or fees as applicable under this agreement. So, and then it shows the schedule down here that the payments are due on the first day of the month.
I really didn't catch that. You mind just 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 going over that one more time because I want to make sure because that paragraph you read that talks about the responsibilities of the tenant. Resident agrees to make full and prompt payments
Right.
according to
Yeah.
the payments.
According to the payment schedule specified below without demand of the owner.
Okay, and let's talk about default because most lease agreements they talk about default. And that's where a tenant usually breaks the lease if they're in default.
That is correct. And Judge, that is what is addressed. Let me pull it up. And it says that in a couple of, so again, it kind of says that here. Again, there's no proration or total rent is due and is equal for the entire term. Total rent stated below is a fixed price for the entire term. Sorry. And then the breach provision, Judge, I'm going to scroll back to that, is under, I think it's paragraph 18. So upon any breach, it says what they are, and then it says under here, without limitation, that the owner may terminate it for non-payment of rent or other charges, etc., about breach of the agreement. So that's what they, and so when they missed, a breach of a contract is any failure to satisfy any contractual obligation. And so, technically, if a payment is a day late pursuant to that schedule back in paragraph 2, it is a breach.
And so what I'm hearing is that whenever the payment, the NSF payment came in December, you're saying that that's when the contract was actually breached. However, it wasn't discovered until March. And that's when the defendants terminated the lease by using the no-show, evict, or skip.
That, correct. And again, that's the form, not any technical language that's under the lease. It's just, that is the form that they have and the kind of the name of the process. You know, Judge, you've got to, I mean, Miss Jones obviously is a fairly young lady, and the staff working in most apartment complexes that I deal with, whether I'm on Miss Hall's side or otherwise, you know, the leasing agents are usually under the age of 30, if not younger. And so that's just kind of a colloquial saying that they've got for processing that move out. They could have processed that in December. They could have processed it in January. And it really is up to their discretion, or they could have waited and, you know, done it over the summer. But all of that amount that, I mean, once it was breached, that full amount under the concession addendum is what became due and owing. And I'm going to flip to that just so, I mean, because that's what is, you know, all net amounts due under the housing agreement, when they are not paid as and when due, the entire concession agreement becomes void and must be repaid. And essentially that is what was breached, because when it wasn't the full amount being paid.
Says it, so all written, that entire paragraph reads, all other provisions of the housing remain in effect and unchanged as consideration of its concession addendum. Resident agrees that if the housing agreement is terminated for any reason prior to the end date, all of the net amounts. So the question is, who terminated the lease?
It doesn't say in here that it matters who terminates. If it is terminated, and then you go back to paragraph 18.
Okay, so what you're saying is that if the lease is terminated for any reason, so what you're saying is that if the tenant breaches the lease, and if the lease is terminated because of the breach, then they lose the concession addendum, and then they're responsible for everything. So is that what, just in summary?
Yes, sir. That is it in a nutshell. And back to paragraph 18 is the provision that just says, without limitation, owner may terminate this agreement for non-payment of rent or other charges.
Okay. Gotcha.
And
All
I
right.
know, Judge, it is a bit confusing. Like I have been representing this client for, my goodness, 13 years. And as you can see, this housing agreement still confuses me at times.
All right. The
So,
next question that I'd like to know, I think you know, we're up to, you know, kind of concluding this right here. I think, you know, I've heard from all parties, just want to make sure I got a clear understanding. The check that was submitted, I need a good clarification on this. If you don't mind, stop sharing your screen.
oh, yes, sir. Sorry.
No problem. This check, the invoice check number 2421. You, Miss Quintessa Hall, stated on the oath that you cashed this check, but the defendant is stating under oath and has proof that the check has been voided and not cashed. I need some, Miss Hall, when did you cash this check? Is the question.
I cashed it this morning, and I do have a receipt showing that I cashed it.
Therefore, that's the reason why they are showing or stating that it hasn't been cashed, because it hasn't cleared the system.
That's correct.
And Judge, it's been voided.
It's been voided, yeah.
So it's going to come back
It's gonna come back as NSF on your end. Yes, so you
On-
cashed it, you went to your bank, you cashed it, and your bank is gonna come back as insufficient or voided, and your bank is gonna charge you a fee. More than likely. Because you cashed a check. I'm just out of curiosity, why today you cashed a check?
Is my mother allowed? May my mother ask a question on my behalf?
I just need the answer to this question. Why cash a check today? Yes, go ahead.
And so we were in preparing for this for today and going through the documents and, making sure we had things in order. Initially, we didn't know why the check was sent. But then when we went back through the documents and saw the one dated August 22nd, that letter in itself states that the account has been reconciled and she will be receiving a check. And so we realized, oh, that's why she received it. And so in our mind, with that document that came, that was dated August 22nd as an account status, and she hasn't received any since. She didn't receive one for September, for October, but with that one being zeroed out, we're thinking, oh, we're actually done then, because they've reconciled it, they've sent her a refund, and so actually, what's the point of this hearing if that's what they've done? And so in all actuality, we came in today just wanting to make sure that, if this has been reconciled, because again, we haven't received any more statements since that one. We didn't receive anything saying this was done in error. There was no written communication saying any of that. So we're just thinking we want to come in and make sure that since nothing was showing that the counterclaim was canceled, we're like, let's just make sure that there are no further charges against us. We've got the statement zeroed out. We've got the check, no further communication. Let's just find out before the judge that there is nothing further to deal with here. But so doing that today was just an attempt to just bring closure to everything, because we really thought it was over.
The next question is to the plaintiff. In your petition, you are suing for $2,160. Why? What is it? What does this add up to be? Why 2,160?
I do not have that paper in front of me at this moment, but if I recall correctly, it would just be what was left of the lease. And really, it was just, I wanted to just be able to pay out what the lease was originally for. So that $509 a month, just being able to pay that out.
So it was 509 times how many months?
I had 4 more months left.
Prior to your lease being terminated.
Correct.
But you also said that your account was charged $4,196. Tell me a little bit more about that.
You said 4,100?
According to your petition, you put down additional plaintiff seeks the following. Credit their account $2,160. You do not want this $4,196 charge held against you. What are you referencing?
That would be the would you say that last number one more time, please?
$4,196. She says, we do not want this $4,196 charge held against us. What is this for? What is this $4,196?
I believe that is referencing the statement I received in March, which would be let me just a moment. Exhibit 4.
Is that say exhibit 4?
Yes.
So you're adding up the balance that's due today and the remaining scheduled payments?
That as of what was sent to me on March 10th. Yes.
Okay.
And really, I just want that amount like that was charged against me canceled. Because I wasn't asking for that to receive money for that, but just for that charge to be dropped.
Man. Just leave the door. Just leave the door. Office usually closes at 4, so I let the ladies go. That's why. They like, we don't want to stay, Judge.
I don't come work for you, Judge.
No, you don't want to work. Okay, so, no, just kidding. As of today, and this is to Miss Jones, as of today, how much does she owe the apartment complex?
Sorry, I was muted. The balance on her account is $3,103.
And that is based on the concessions being removed because she breached the lease, what you're saying.
That is correct.
And that's at 679.
Yeah, the base housing installment rate was $679, and then she had $10 trash pickup, and then the concession was give me 1 second, let me pull it back up. I apologize.
100 and something.
The concession was $180 against each installment.
But what you're saying is that she breached. She lost the concessions.
Correct, which
And then
is why
because
the 3103 is outstanding.
And that's based on 689 less any payments she made for those months that she was receiving the concessions.
Correct. So I have a payment from August or a payment in August all the way until the payment in March, and then I don't have a payment for April, and then I have a payment for May and June and don't have a payment for July. So that is included in the 3103.
And Judge, just for easy math, if you look at the concession addendum, it's the $180 a month, but it's the total rent concession is listed there. That's the $2,160. And then we're also requesting attorney fees on this, and it has been, well, now a little bit over, but I will cut my time off at 6 hours in total, and that includes all the time today. The rate of $400 an hour, so for $2,400. And I'm happy to testify, Judge, as to my qualifications and licenses, etc., if you would like to hear that.
Your opportunity to testify in regards to that. That's part of the case. Go ahead.
Okay. Judge, I'm an attorney licensed in the state of Texas. I'm also licensed in the District of Columbia and the state of Florida. I have been licensed, oh my goodness, for over 20 years now. And I've been representing the Sion group since I believe 2011 or 2012, doing agreement or litigation for them under housing agreements such as this throughout the state of Texas. I think my rate of $400 an hour is a reasonable and equitable rate for an attorney that, you know, practicing in a court in McLennan County, Texas. I'm familiar with the McLennan County area. I was born in the big city of Marlin, and so I'm a Falls County girl, and so I am familiar with the legal services in the area and currently practice in Brazos County.
All right, thank you.
Yes, sir.
Okay.
Your Honor, may I ask a question to get clarity from the lease? Or is that time passed?
I think time's passed. I think I've heard everything I need to hear. I've heard everything. All right. So justice courts will not court your record. I want to make sure that I say this, say that up front. I've heard a lot in today's hearing. Okay. With regards to this lease that was initiated back in August of 2024. Now, at that time, the leasing manager was there and represented the owners of the property's interest. One thing that I've heard that it disturbs me is all of the errors that occurred throughout this lease. The other thing that disturbs me is the constant transitions based on what I've heard today of management at this particular property. And I think that was a major problem with how we got to this point, honestly. Ms. Jones, I think you're doing a great job. I think you're trying to get everything up and running the right way. And trying to get staff there to do the right thing. Ms. Bedingfield, great attorney. However, I'm going to rule in favor for the plaintiff. And those were the reasons why, is because of those constant errors that occurred and the fact that you continued accepting the payments according to the agreed terms initially. But you come back, not you personally, your on-site management, because you're not there, Ms. Jones. Your on-site management came in and somehow terminated this lease for whatever reason and want to charge this plaintiff with the excess. So the judgment amount is going to be what she actually owes you plus court costs. I think that will be a reasonable way of settling this particular suit. The judgment is going to be for $3,103 plus court costs. And hopefully, once everything's said and done, there should be some type of agreement that's going to be sent to both parties, settling all of this dispute and closing this thing out completely. Judgment for the plaintiff, $3,103 plus court costs. Thank you, Judge.
Thank you, Judge.
Thank you.